We say this because these days it is common and it's a bizarre practice to see lawyers, especially those in the Nuwi cadre, to wear their official regalia. They defy what we call the defying and ill-inspiring paraphernalia of the profession, well, without a way, and serve as pillar passenger of cadre. That is at every nook and cranny of the town. It is a transgression of Rule 45 of the RPC. By the same token, a rating of lawyers are enveloped in poverty and destitute of funds to run legal offices because of the economic crunch. To this end, they patronize and employ computers to public business centers as their offices, where sensitive legal documents are prepared and printed, and the staff therein as their own secretaries. This is despicable and it fractures Rule 41 of the RPC. That is not all. Because of the economic crunch, lawyers are propelled to engage in an untoward act of confiscation, diversion, and conversion of clients' money, which is too bad, and that's one of the roadblocks to achieving excellence. These flagrant abuses of legal ethics, statutory worse at that, constitute serious erosion of the integrity of advocates at the bar and an obstacle in the clear route to excellent legacy in the legal profession. A university done expressed the bar perspective. I didn't want to go to the base perspective, so let me speak because today is for the bar. Before I go on, I would want to whisper with the organizers, the person, to know how many minutes I'm giving. I say this because in dinner speech, people will be salivating to eat their food. There will be clenching some plates so that I do not or hurt the truth. He must produce all the relevant authorities, even when those are against his client, see his clients, even when the case is against his client, the relevant documents, even those that are fatal to his case, and disregard the most specific instructions of his clients when they are incompatible with his duty to the court. The code which enjoins an advocate to do all this is not a code of law, it is a code of honor. If he breaks it, he will fail the rules of the profession and is subject to his discipline. A lawyer that idolizes integrity owes the duty of friendliness and comradeship to his colleagues. The spirit of camaraderie pervades the bar, both the inner and the outer bar. Hence, lawyers address themselves hearing and control. But the society itself is ahead of the law, and the law struggles and toddles to keep up with the developmental pace to be able to regulate it. This is because law evolves organically and sometimes politically, while the society it regulates evolves rapidly and spontaneously in response to available data and process. Law is only reactive to societal trends. Societal changes are precursors to the dynamics of law. To Lord David, the law never stands still. It goes on a pace. You have to run fast to keep up with it. The law is not a stagnant pond, but a living river, ever flowing through the terrain of human progress. The excellence we seek must be intellectual, dynamic, and overrenewed. The need to acquire skills is no longer a discipline but a necessity. To be a lawyer of legacy, one must transcend the mere mastery of procedure. We must be students of humanity, economics, technology, sociology, and philosophy. Justice Benjamin Kadisu aptly declared, the law which is the resulting product is not found but made. Every submission infancy career is a chisel shaping the sculpture of justice. A good lawyer's submission should both inform and educate the court. Indisputably, the profession has monopolized the word learned as the complement of lawyers. The term is deeply planted in the idea that lawyers are learned in law, which involves deep study and continuous learning across various fields of human